So I could send you to prison for 10 years and they'll put you on a schedule. And you may have work at the prison. I don't know if they still do the thing like they do in the movies where you make license, but I have you on GPS and you're not charging your device. I don't understand this. All right, good luck to you. I don't want to see you back here for this again. You understand? Grant the motion, sentence you to 5 years in the prison, give you credit for any time served.
I'm sorry, this plea has gotten so cumbersome. The cap, there was supposed to be a cap of 4 years, so you could sentence her from 2 to 4 years.
No. Y'all are not allowed to tell the court if she's applying for deferred adjudication, how much I can sentence her.
There is no family violence in this case.
No, there is.
There is,
No, there is.
she's not related to any of those people.
So why did you ask for treatment?
To not have jail time. Is there any way I could get treatment?
And you told this court you don't need treatment.
Okay,
No, you told this court the only reason you said that is because you didn't want to do the jail time.
Calling 2024 CR 2942, State of Texas versus Patricia Munoz. Can I have parties announced for the record? For the state?
Jason Garahan, Your Honor.
For the defense?
Anthony Cantrell.
Are you Patricia Munoz?
Yes, Your Honor.
All right, defense, you filed a motion to quash the indictment. Are you withdrawing that motion?
We are, Your Honor.
Any objections to withdrawal of the motion? The appropriate places.
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a
Yes, Your Honor, we would like to orally strike, and we can do it on paper as well, the affirmative finding, Your Honor.
All right, so here's the thing with the affirmative finding of family violence. I need to put you on notice what that means. Now, I will read through the police reports, and if it's a family violence matter, then I'm going to find there's an affirmative finding of family violence. But if it's not, then I won't make that finding. Does everyone understand?
Understood.
Yes, Your
All
Honor.
right. So outside the agreement, in the event that I do not grant your application for deferred adjudication, the state is going to recommend that your punishment be set, capped at 4 years in the prison. Did you understand that would just be a recommendation from the state and the court would not have to follow that recommendation?
Yes, Your Honor.
So
And Judge, that's not how I'm sorry, this plea has gotten so cumbersome. The cap, there was supposed to be a cap of 4 years, so you could sentence her from 2 to 4 years.
no, y'all are not allowed to tell the court if she's applying for deferred adjudication, how much I can sentence her to if I don't follow your agreement. I mean, I'll take it in consideration if I were not to, I'm sorry, not agreement. Your plea bargain is that the state is to remain silent on your application for deferred. So what that means is the state is not going to tell me that they don't want you to have deferred. They're not going to tell me that they do want you to have deferred. Hypothetically, if I were to grant your application for deferred adjudication, the state can make a recommendation and say, Judge, we want her in deferred adjudication for 6 years. I could say, well, no, I'm only giving her 4. I still will have followed your plea bargain agreement. Or, oh, well, I'm giving her 8 years deferred adjudication. I will still have followed your plea agreement. The suggestion that your sentence be a cap of 4, that's not a part of your plea agreement. The part of the outside the agreement is if I do not grant your application for deferred adjudication, then the state will ask that you be sentenced to no more than 4 years. But I don't have to sentence you to 4 years. I could sentence you to more than 4 years. Am I going to do that? I don't know. Am I going to grant your application for deferred adjudication? I don't know, because I'm going to need a PSI report. So that's the agreement. And if people don't understand that as agreement and want to withdraw, you're more than welcome to withdraw. But as far as the state's recommendation of a cap of 4 years, if you don't receive deferred adjudication, that's just something for me to consider, but I don't necessarily have to follow that.
Understood. We'll still go forward.
All right. So does everyone understand that if the court were not to grant the application for deferred adjudication, that I could potentially sentence you up to 20 years in prison. Do you understand that?
Yes, Your Honor.
Do you understand that the fact that the state would perhaps recommend or will recommend a cap of 4 if I don't grant your application for deferred adjudication, that's just something for the court consider. Do you understand?
Yes, Your Honor.
And do you understand that if I were not to grant your application for deferred adjudication and the state were to recommend that you be sentenced to 2 years, 3 years, or 4 years, and I decided to sentence you to 10 years, that will not have violated your plea bargain agreement. Do you understand?
Yes, Your Honor.
All right. Then to count 1, my understanding you've entered a plea of no contest. Is that correct?
Yes, Your Honor.
State any evidence.
Yes, Your Honor. State offer states 1 and attachments.
No objections.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Probation, I'm going to request a PSI and TAP evaluation. Counsel, is there a need for a mental health evaluation or no?
No.
All right. Ms. Abrams, if I set this for July 22nd or 25th, is that enough time or no?
So Judge, can I have at least till July 31st?
I can put it at August 1st. All right.
Good with-
All right, what's going to happen on August 1st? You're going to come back. I'm going to make my decision on your application based upon the PSI report, the TAP evaluation, and any other evidence that's presented to the court. Do you understand?
Yes, Your Honor.
All right, once you sign the reset form, be sure to speak with probation. They'll give you information on what needs to be done, and we'll be back on August 1st at 9.
Thank you for the help, Judge.
Thank
Oh,
you, Your
sure,
Honor.
no problem.
Thanks a lot, Judge.
Here you are. Patricia Munoz. All right, could I have the parties on Patricia Munoz, please?
Yes, Your Honor.
All right, we're back on the record in 2024 CR 2942, State of Texas versus Patricia Munoz. We do have the caseworker by Zoom. Could you pronounce your name for me, please?
Angie Steinow.
All right, Ms. Stownell, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Angie Steinow.
Do you know Miss Patricia Munoz?
Yes, I do.
All right, are you the caseworker involving her family case?
Yes, I am.
All right, are you her caseworker or the children's caseworker or the family's caseworker?
The family's caseworker with Family Drug Court.
All right, can you tell me what is her status in drug court? How is she doing?
Ms. Munoz is almost completed the Family Drug Court program. She has successfully been engaging in individual counseling, family and group counseling with her domestic violence and her substance abuse treatment. She has been randomly drug tested throughout the duration of the case, including hair follicles, which she has tested negative. She also has been reunified with her children since May the 3rd, and the department has done very frequent visits, almost weekly and bi-monthly for the last couple of months. And she's been compliant, doing really well.
When is she due to expire from or graduate from your drug court program?
I believe it's the end of this month. She is in the stage 5 of Family Drug Court, which is the last stage.
And do y'all provide aftercare after graduation or no?
Yes, we do. And she also has a sponsor and a relapse plan.
And how long is your aftercare after she graduates?
It's at least 6 months, and she will continue to do NA meetings.
And in your aftercare program, how often are you all still supervising, viewing the children to see that everything is going well?
We don't particularly observe the children, as CPS will be closing out their case as well. So that will be Miss Munoz going to the continued aftercare program on her own.
All right, so then in your aftercare program, how do you specifically supervise Ms. Munoz?
She will continue to report to her, one of the counselors at Elite Counseling.
And how often does she report to elite counseling in the aftercare program?
Twice a month.
All right, and if there are any issues with her reporting in elite counseling, are you all made aware of that?
Yes, we are.
All right, any other questions?
Nothing from the state.
No, Your Honor.
All right, a final question for me then. Do you think she would be a danger? I'm assuming you all don't think she would be a danger to her children, otherwise you would not be closing out the case. But do you have any concerns about her interaction with the children, or any concerns for her children if she were allowed to be placed on probation in this court?
No, I don't.
All right, do you think there are any conditions that this court should set to make sure she stays on the right path?
No.
All right. Anything else? All right, thank you. Thank you for zooming in.
Oh, you're welcome. Thank you.
All right. All right, court's going to sentence you to 8 years deferred adjudication. I always ask for parenting classes, but if you completed parenting classes, you'll just need to provide the parenting classes that you've completed through family drug court. Do you understand?
Yes, Your Honor.
All right, there's going to be proof of employment within 40 days. There should be no employment as a home health care provider or with minors.
Judge, may I interject on that? Is what she has been doing for the last 10.
Doing what?
Yes,
Healthcare,
Judge.
healthcare provider.
And her whole life she's been doing it.
Well, here's the thing. I don't allow people to be healthcare providers when they're on probation in this court. If you want to be a healthcare provider, then there needs to be notice given to whoever you're employed with saying, I know this is what she's charged with. I know she's on probation for this amount of time, and the person that you're providing the healthcare for also needs to be made aware of that. And I need that in writing saying that they have no problem. Otherwise, you're not allowed to do it.
Yes, Your
And
Honor.
let me just tell you, I'm not treating you any differently than anyone else. The reason why I do that is because sometimes these home healthcare providers, they would just hire people. They go into people's homes. Nobody knows if this person is on probation, has a theft, has an abusive history, and they're leaving them with somebody vulnerable. So I'm not going to allow her to be a home healthcare provider probation unless she provides a letter from her employer, and that employer states, and it's notarized, that they're aware that she's on probation for aggravated assault with a deadly weapon, and they're aware of her criminal history. And whomever she is providing the health care to, the individual, they need to provide a notarized letter saying, we know that she's on probation for aggravated assault with a deadly weapon. Here's her history, and it needs to be notarized, and they have no objections. Otherwise, she will not be able to do that.
Understood.
There's to be regular reporting by Zoom or in person. There's to be regular random UAs. You can do the UA or the patch. Probation will explain to you the patch costs more. There's to be no contact with Miranda Medellin. And for the record, the court did not receive any documentation in the PSI from Miranda Medellin. And there's also to be no contact with Renee Vasquez II. There's to be 120 hours of community service restitution. I'm going to order parenting classes. If you provide proof that you completed parenting classes to family drug court, that will be deemed satisfied, and the community service hours will be deemed satisfied. Field visits one time per month for 4 months. And that one time per month is to begin November of 2024. I'm trying to time it a little bit, probation, with when CPS ends their contact with her. There is to be drug treatment, or I should say continued drug treatment with Elite counseling, and you're to report 2 times per month with them. Probation, is there anything else she needs?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to
Judge.
own.
There is no family violence in this case.
No, there is.
There is, she's not related to any of those people. And
There is.
we discussed that. We discussed that last time, also. Prior to-
No. This is the niece, these are all family members, and she said it's the niece of the father of her child. Did she not say that?
Yes.
These are family members. So there is an affirmative finding of family violence. And because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And with regards to the affirmative finding of family violence, it's in the family code. I follow it. If for some reason people believe my interpretation of the family code is incorrect, we can always revisit that. But for now, my interpretation of the family code is this is an affirmative finding of family violence. And my hands are tied. I can't say I'm not gonna have an affirmative finding of family violence. Do you understand?
Yes, sir.
All right, we're off the record. Make sure you stay in contact with your probation officer. If there is an issue, let the court know and we'll take it up. You understand?
Yes, Your Honor.
Good luck to you.
Thank you.
5-5, State of Texas versus Philip Kendall Harris. Can I have parties announced for the record for the state? Defense?
Joseph Appelt for the defense.
And are you Mr. Harris?
Yes, Your Honor. Mr. Harris speaking.
Okay, so we're making a correction on the plea paperwork. We're changing the state's recommending deferred adjudication. We're not recommending community supervision.
That is correct, Your Honor. It is a correction to deferred as opposed to community supervision. Straight probation is a deferred adjudication rec by the state.
All right. So, Mr. Harris. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
With your permission, yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, if I may. With respect to this incident, the complaining witness and the child involved are no longer in contact. Mr. Harris is no longer in contact with them. The child is not related to him at all. He has no ties to this person whatsoever. Mr. Harris currently resides in Fulton County, Georgia, which is around Atlanta. He has no intentions of returning to Texas or anywhere near where Ms. Woods would be. So with respect to that, I think that the possibility of any future incidents occurring is slim to none. Mr. Harris also is self-employed. He does some DoorDash as well as the Uber Eats, but he's also raises dogs where he is in Atlanta. And with respect to that, we would respectfully request you to follow the plea bargain agreement and also permit transfer to Fulton County, Georgia.
All right, what dogs are you raising?
French Bulldog.
Okay. That she accused you of cheating. She was going to leave with her 2 children in a vehicle, but you took off in the vehicle. And when you took off in the vehicle, she put the deadbolt on the apartment door. You knocked and you kicked on the door. She wouldn't let you in. The 1-year-old, who you're not the biological father of, was walking towards the window. And I'm assuming this is reckless because maybe you didn't know the 1-year-old was near the window. You threw a rock, the glass breaks, and the child ends up with glass underneath their eye. So if you would like a jury trial, then you can have a jury trial. We'll have you come back from Fulton County, Georgia to have your jury trial. But the stipulations that you agreed to is that, yes, a rock was thrown through the window. What it says,
Yes, I didn't throw a rock through a window, but the charges, I mean, the circumstances, uh, I was taking the plea deal because
so
I
you're
didn't
saying you
want to
didn't
go.
break a window.
No, I wasn't. It
So
was
how
an
did the child
argument
get
and
cut
I
underneath
left.
the eye?
I never was there for that. I don't know. But that's not the first time that we had to replace a window because she threw something through the window months prior to that. So I don't know if she did that when I was not there, but I never threw a rock through the window. I wanted to make that clear.
Then
To-
it sounds to me like you should go forward with a jury trial. Because you're saying it didn't happen.
Do that.
So what are we pleading to?
No contest.
Yeah, but the police report is saying that you threw a rock through a window. And that's how the child ended up with a laceration under his left eye near the outside corner and high on the left cheekbone. They say they photographed the scenes. So there's no doubt that this child had a laceration. He's one. He had a laceration under his eye. Somebody caused the laceration under his eye, be it recklessly or intentionally. You're saying it wasn't you, so it sounds like you need a jury trial.
I don't.
You want to
I just
discuss it
wanted
with your
this.
attorney?
No, I had discussed it with him, but I just this
Here's
whole
the thing.
process.
I am not accepting a plea bargain agreement. I understand what people saying they're not fighting the charges against them, but you're saying you didn't do it. You're saying you didn't break a window. This entire case is about a window being broken, a rock being thrown through a window, and the window breaks, and a 1-year-old ends up with the laceration beneath his eye. You're saying you didn't throw a rock, you didn't break a window. That is completely different from I'm not fighting the charges against me. So sounds like people want a jury trial. Is that what this is, Mr. Pelt?
Mr. Harris has indicated that he doesn't want to have a jury trial, but he is also saying that he didn't do it. So he wanted to do the plea and accept the 2 years deferred. And I understand the contradiction that we have here, Judge.
Yes. So it sounds like you all need a jury trial. Because this is not your normal no contest plea. He is saying 100% he didn't do it.
I understand, Judge.
So we'll schedule for a jury trial.
We can do that, Judge.
All right, what date?
If I can get with Mr. Harris to find out what his calendar is like with respect to the any obligations he may have and what the court's current schedule is for trials.
Oh, I'll give you a schedule. Norma, can you set this in December, please? State, how long do you expect this trial to last?
2 days.
All right, it's 2 days. All right, we'll come back on December 2nd for jury trial.
Judge, I have a mediation that day.
All right, we'll put you on the, we'll still set it for December 2nd and we'll take you up on the 3rd.
Okay, Judge.
Thank you.
Thank you, Judge. May I be excused? Oh, Judge, I also had another client on the docket and that other client did not show.
All right, just give me a moment.
Sure.
Who is your other client?
Last name is Mesquias, Mesquias. First name Victoria.
All right, could I see that file, please?
Let's do it.
It's cause number 2023 CR 7097.
All right, court is calling 2021 CR 8755 State versus Philip Harris. Can I have parties announced for the record for the state? Defense.
Joseph Pelt for the defense.
And are you Mr. Harris?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Probation, this is an application. Mr. Harris, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review, let me see if I can find it. Did you review the true bill of, off the record? I have 2 stipulations. I guess he changed his mind. 'Cause
We
I-
were here, I believe, in October for a
Yes.
plea, and then that's
Okay, let me just paper clip this so there'll be no confusion. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
With permission of the court, yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Harris, he actually resides in Lawrenceville, Georgia, which is in Gwinnett County, Georgia.
Mhm.
That's where he before he got picked up on this warrant, Judge, he was gainfully employed with Delta Airlines as a ramp agent. He
Mhm.
believes that job is still available to him, being that he has family members that works there as well, and he believes it's held open for him. He wants to get this particular chapter of his life behind him and moving down the road in a positive manner. He does live with his mother currently, along with his significant other, Demetria, with whom he has a 2-year-old child. And he wants to put that as his main focus after he finishes this, because he wants to make sure that this never happens again.
Explain something to me. Why are adults out here having children and then have to go move back in their mom, in with their mom and their child? I'm sure your mom doesn't want that. Now your mom has to be a parent to a 2-year-old. She shouldn't have to be the parent to, because she's the grandmother. So your significant other, and maybe this doesn't have anything to do with the price of peaches, we shall see. Your significant other who's living in your mom's home, does she have employment?
Yes.
So what that means is you're using the grandmother of your child as a babysitter. Does she charge you for that?
No, she does not charge.
See, this is people taking advantage. This is what I always say. When people want to decide to have children, you know what they need to do before they have a child? They need to say, all right, let me sit down and talk with the grandmother. Will you be willing to be more than just a grandmother and be a full-time babysitter and daycare person? Oh, and by the way, can we live with you because we can't afford to live on our own and we can't afford a daycare? People just out here in the streets having children and expecting other family members to step up and take over their position. When if you can't afford a child, honestly, you should be thinking about that before having a child. You understand?
Yes, Your Honor.
And then this lady here in this complaint, was your name on that apartment?
No.
Then why do you think you should be there? And then she said, you all got into argument and she just want to leave because you're cheating on her. Were you cheating on her?
No.
Well, she thinks you were. So woman's intuition, and she just want to leave. But before she can even leave, you take off in her car. Was that car in her name or your name?
My name.
All right. So you take off and leave. You come back to an apartment that is not in your name, and you're throwing rocks through a window, like Ernest T. from Andy Griffin. Who does that? You understand?
Yes, Your Honor.
All right, there's $1,000 fine. It's going to be probated, affirmative finding of family violence, 4 years deferred adjudication, 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Regular reporting by Zoom or in person, regular random UAs, anger management. And we'll do a transfer to Gwinnett County, GWINNETT County in Georgia. TAP evaluation. Follow Rex. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. There's to be no contact with Caitlin, Kaitlyn Woods, or Elias, Elias Woods. Proof of employment within 30 days of release, no employment as a home healthcare provider or with minors. And if they have field visits in Gwinnett, then it's going to be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor. You showed me everything.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand? All right, and we can go off the record. Here's the thing. Since your mom is taking care of your child, being a daycare for your child, sometimes she gonna need a break. Sometimes you and your wife, you know what you should get together to do? Let her leave, give her money so she can go to a restaurant and just get away from it all. And then if she has a curfew with people and she don't want people coming in her house at 1 a.m., don't do that. You need to do that at your own house. You understand?
Yes, sir.
And don't go to her saying, but me and my wife need a break from our child, because guess what? She's not getting a break. It's 24/7. So
Yes.
make sure you give her a break and do not have any more children until you're ready to have your own daycare, because people get in a habit and they say, oh, well, let's have another child. Grandmother will take care of her. She wants to enjoy her downtime. You understand?
Yes, Your Honor.
All right, good
I
luck to you.
appreciate all everything you tell me.
All right, good luck.
Thank you.
And tell your grandma, tell your mom you love her.
Sure.
All right,
Thank
good luck to you.
Thank you, Judge. May I be excused?
Yes.
Good luck to you.
All right, we're gonna take. No, you may not.
Thank you.
You're welcome. Corey, it's a beautiful day. Court, as you understand, you're charged with violation, protective order, assault, stalking. I'm sorry, this is written backwards. Just 1 second. All right, we're back on the record. You're charged with offensive violation, bond, protective order, assault, stalking. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. How the court would defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing, or is there going to be a PSI?
We would like to waive sentencing, or PSI.
State any objection to the waiving?
No objection.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, Mr. Linsky, he has struggled since he was a young boy with his mental health. He is currently, we actually went through the mental health PTD evaluation and program, and he actually was a good candidate until he picked up his most recent arrest. All of his arrests and all of these problems are stem from his interactions with his wife, possibly soon to be ex-wife, but he is very dedicated to his family. I will say, and I believe the state would agree with me on this, all of the incidences of the violation of protective order, he has been at his place for his GPS unit, he has been at his place that he's agreed with the court, he will be like his home base for the GPS. She has come there. We're not saying that it's an excuse or reason, but we just like to point that out to the court. He's not going after her or anything like that. It's an unfortunate situation between the two of them. I think there's a lot that needs to be worked out in family court. However, with his current, he does need mental health treatment. He is current with his doctor. He is current on his medication, but it's a lifelong struggle with him, and it's going to continue to be a lifelong struggle with him. It's extremely unfortunate. He's an extremely intelligent person. He had a full ride to UT at one point, but because of his mental health struggles, it's just been this almost spiraling events in his life, and he does want to. I've talked to probation about the MyOff program and the MIC docket. Sounds like a lot of things that he would benefit from wholeheartedly, and he wants to do anything and everything that is available to him, and the court would be willing to allow him to do.
All right, state, is the complainant aware of this agreement?
She is, Your Honor. She wants him to get treatment.
Okay. All right, do you have any children?
Yes, Your Honor.
What are their ages?
2 years old.
And are they with the complainant?
No, my mother and father.
And are you employed?
Yes.
What do you do?
I work for a psychiatry clinic. I proofread referrals.
His mother is a psychiatrist, Your Honor. He was working for her because that was the only thing that he could do when he was in-home arrest, like with the GPS unit, so he was working. He actually was given a job, but because of the rearrest, he hasn't been able to start it, but with, and correct me if I'm wrong, but computer software with a health organization.
Yes.
It was mainly online, but because he's been in custody for a few weeks, we'll have to see if he still has that job.
All right, so I'm going to put him on GPS. So the only question is, state, are you in agreement to allow him to be employed while on GPS?
We're fine with work release on GPS. You know, we'd ask for documentation.
All right, the court is going to sentence you to 6 years deferred adjudication, $1,500 fine, probated. This will run concurrent with County Court Cause number 656156. The court will show that the plea bargain agreement in that case is for judgment satisfied. Take in consideration County Court Cause number 656155, 685313, grand jury numbers 767-287, 774-493, then 48 hours to be waived. There's going to be parenting classes. The remaining of the community service hours will be waived once you complete parenting classes. There's to be no unsupervised contact. There's an affirmative finding of family violence. The weapon is to be destroyed. GPS, waive fees. And that's to be partial GPS. Defendant allowed to work upon proof of employment and work schedule. Is there anything else?
Nothing from the defense. Your Honor.
Probation, is there anything else that he needs?
Your Honor, did you mention regular year analysis?
No, thank you. There'll be regular UAs. All right, is there anything else you need from the court in order to be successful?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, and then the court has the motion to destroy, so that has been signed. Is there anything else for me to sign?
No, Your Honor.
All right, good luck to you.
I have to excuse, Your Honor.
Yes.
Thank you.
Let me see the file on Mikado, please. Court is calling 2022 CR 0266. He needs to be in the middle. State of Texas versus Igor Elinsky. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Ken Lock for Igor Olinsky.
And are you Igor Elinsky?
Yes, sir.
Showing you what's entitled motion to enter adjudication of guilty and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilty and revoke probation. Did you review that with your attorney? Did you understand it?
Yes, sir.
All right, off the record for a moment. I'm sorry, I'm gonna have to ask you all to be quiet in the box while we're on the record. All right, we're back on the record. Are you the same Igor Elinsky who was placed on deferred adjudication in 2022 CR 0266 for the offense of violation bond or protective order stalking on June 6, 2022 for a period of 6 years? Is that you?
Yes, sir.
State.
Your Honor, in violation of condition number 4 in Bexar County, Texas, the defendant Igor Elinsky did then and there fail to report to the supervision officer as directed for the month of November 2022 in violation of condition number 4.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining.
Any objections to the state's waivers?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty and sentence you to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Sure.
Court will find violation of condition number 4 true. Is there an agreement?
Your Honor, we do have an agreed recommendation to deny the motion to assess a 30-day jail sanction, to alter and amend for bi-weekly, meaning twice a week visitations for the first 90 days upon release, and to require him to re-enroll in the BIP program within 5 days of his release.
All right, is that the agreement?
What is the agreement, Your Honor?
All right, so here's the court's issue. And I don't take the other allegations as true because you all weighed them. But I have you on GPS and you're not charging your device. I don't understand this.
It's busy with work, I guess, forget the things I usually do.
All right, so I could send you to prison for 10 years and they'll put you on a schedule. And you may have work at the prison. I don't know if they still do the thing like they do in the movies where you make license plates and you get paid $1 a license plate or 50 cents. So would you like to not be busy at the jail or at the prison? Because I can arrange that.
Not on the table, Your Honor.
Well, here's the thing, you're going back on GPS. And if you don't charge that GPS, you're going to potentially go to prison for up to 10 years. Do you understand?
I do.
Now, here's my question. Explain to me why I shouldn't send you to prison. What has he done since he's been on probation? Has he done anything?
I believe he completed the parenting course.
What have you completed?
Been doing my drug test, all the appointments, what I'm supposed to make. My probation officer, I keep paying fees. Yes, I'm also employed.
He did get a job, Your Honor. And one thing, when I pulled up the original conditions, it did say partial GPS with proof of employment. I don't know if that was done. I know as part of his condition of bond, I requested full GPS.
Okay, here's the thing. This is what I can do. I will send you to prison for 3 years. You can do whatever they want you to do at the prison. And you will be done with this probation. Or I can continue you, but you are going to be on GPS and you will follow the rules of GPS.
I would like to continue with my probation, Your Honor.
All right, this is what the court will do. You will approach Caroline, they have it. Thank you. All right, we're back on the record. The court will deny the motion, alternate amend conditions to include GPS, and that will be partial for work only. I'm going to want field visits 1 time per month. He's going to enroll. You said the BIP program?
Yeah.
You're going to enroll in BIP within 1 week and all of the conditions will remain. So your GPS, you're only allowed to go to work. You're not allowed to go to the grocery store. You're not allowed to do anything else. It's work. If you need groceries and you live by yourself, you're going to have to use Instacart. Do you understand?
I do, Your Honor.
Or some other thing that they use. All right, is there anything else you need to be successful?
No, Your Honor.
All right, good luck to you. I don't want to see you back here for this again. You understand?
Yes, Your Honor.
Thank you, Your Honor.
You're welcome.
Let me be excused.
Yes.
Morning, Your Honor. Shannon Mock for Igor Alinsky.
All right, so while you're there, you need to be on this side and your client is in the center. What is happening with this case?
So, Your Honor, Mr. Alinsky took a drug test this morning. He has also provided a list of prescription medication to probation. We would like to get a more formal list of prescription medication to probation.
But it says here that he hasn't given them proof of employment, that he's been using alcohol, which you're not allowed to use. There's some issue with the GPS device that's been shutting down. So what are we doing?
We dispute most of that, but they did want him to take the drug test today. He passed except for something he does have a prescription for, which we're going to provide a better copy of to the probation department.
All right, Ms. Ferguson, I need a contested hearing date on Mr. Alinsky, please. All right, June 8th is your contested hearing date.
Thank you.
Thank you. All right, is this going to be a plea of truth?
Yes, to the 2 new number 1s, Judge.
All right, court is calling 2020 CR 0266. State of Texas versus Igor Alinsky. Could I have parties announced for the record? For the state?
Hank Wilkins for the state.
Defense?
Elizabeth Russell for Igor Alinsky.
Are you Igor Alinsky?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Igor Alinsky who was placed on deferred adjudication in 2022 CR 0266 for the offense of violation of bond or protective order, assault stalking on June 6, 2022 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
On or about, violated condition number 1. On or about the first day of October 2023 in Bexar County, Texas, the defendant Igor Alinsky committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
violated condition number one, on or about the first day of October 2023 in Bear County, Texas. The defendant, Igor Ilinsky, committed the offense of fail to stop and give information over $200 in violation of condition number one.
How do you plead to that? True or not true?
True, Your Honor.
Violated condition number two, on or about the first day of October 2023 in Bear County, Texas. The defendant, Igor Ilinsky, did then and there consume alcoholic beverages in violation of condition number two.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violations 1, 1, and 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 1, 1, and 2?
Yes, Your
Court will find 1, 1, and 2 true. Is there a proposed agreement?
There is, Your Honor. We're asking you to grant the motion, adjudicate the defendant guilty and sentence him to 5 years in the prison.
Is that the agreement?
That is, Judge.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, this is what the court will do then. The court will find you guilty, grant the motion, sentence you to 5 years in the prison, give you credit for any time served. There's to be a $1,500 fine, time and money. Will run concurrent. There's an affirmative finding of family violence. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, good luck to you. You're welcome.
With Megan.
All right, Megan.
So Judge, this is a case I took over for Tony Jimenez. He had withdrawn. There was an additional file that was filed under a AKA.
Mhm.
And I need some additional time to go through all the discovery and then figure out what motions to file. And then also to file a speedy trial motion. But I asked for, last time we were here, I think they couldn't find the files. They found 2 of them, and the other one is under a different name, and they're going to get that one too. But I think we should have all the discovery.
All right, so does he only have 3 cases?
That's my knowledge, yes.
All right, so you have all the discovery?
My understanding, yes.
State, were you able to tender an offer?
There's one in the file, Your Honor.
All right, so what I'll do is I'll set it for a plea deadline date.
No.
Counsel, how much time are you asking?
I'd say 60 days if I could, Judge, so I can go through all this stuff. I'm pretty backed up in January, particularly in this court.
All right, Ms. Ferguson, if I can have a 45-day reset for a plea deadline date on McKinney?
Very Solomonic, split the difference.
See, there you go.
I can do February 3rd.
All right, February 3rd, that's when we'll bring you back. On that date, you need to let the court know whether or not you've reached an agreement with the state. Do you understand?
Yes, I understand.
All right, do you have any questions about anything?
Yes, ma'am.
Sure.
Judge, if we could, can we do the 4th? I'm set on the jury docket in Atascosa and district court. I don't think I'll go, but I'll need to announce.
Norma, can you put this on the 4th?
Yes, ma'am.
All right, thank you, Judge.
And you said you had something you wanted to say?
Yes, ma'am.
Have you cleared that with your defense attorney to see if it's appropriate?
Judge, if he wants to speak, I have no problem with that.
All right, yes.
Thank you a lot. And if you would, may I please establish this on the record, please?
Oh, sure. We're going on the record in 2024 CR 009238, 2024 CR 012230, and 2024 CR 012200, State versus Raymond Lee McKinney. Could I have parties announced for the record for the state?
Megan Galloway for the state of Texas.
Robert Mauer for defendant.
And are you Mr. Raymond Lee McKinney?
Yes, I am.
All right, there's something you wanted to address?
Yes, ma'am, it is. I want to bring to the court's attention from the onset and cause number 2024 CR 009238.
from the onset, I have expressed my desire with the attorney before, Antonio Jimenez, in addition to Mr. Robert Maurer, my wish to proceed in the fastest fashion possible.
Okay.
In addition to that, with the other causes or case numbers, 2024 PF 1622 4 and 2024 PF 1622 I've done the same, considering Mr. Maurer has been the attorney in that, in those matters solely. Here it is. It's from the June case in CR 009238. I've been pending prosecution since June 14th to be exact. And even with the court, with the presiding, I have expressed same assertions. And I'd like for the record to reflect that I insist on moving as fast as possible. I understand that Mr. Maurer here has other matters, but I mean, I'm constantly being put at the back end of those matters or at the bottom of the totem pole, so to say. So if the court would, no disrespect to Mr. Maurer, I'm pretty sure he's a swell attorney. Provide me somebody who could aid and assist me in the matters as speedily as possible.
Judge, I would have no objections to withdrawing. I tried 3 cases in the last 2 months that are jail cases, including a murder case and a sexual assault. So if you want somebody else, Judge, I would be more than happy. There are many able attorneys that I'm looking at in this court who would do a great job on this case.
All right. I appreciate that. Let me explain.
And again, I
something.
mean.
No. Let me explain something to you, Mr. McKinney. I understand what you're saying. And the state of our society has always been that there are always people who are alleged to have committed offenses. So I want you to turn around and look behind you. No, turn around, look, turn around, look behind you. All of those people are defendants who have cases on the docket. Look in the box. All those people have cases on the docket. There are cases that are capital murder cases that are set for trial that are ahead of yours. So even if your attorney were to say, I want to go to trial today, number one, we can't go today. Are there jurors even today? There are no jurors scheduled because they're taking time off for holidays. So even if you wanted a jury trial today and I was able to give you one today, I can't because I don't have any jurors. And what I can tell you is the inmates in the box cannot be on your jury panel. I think the state would probably object to them. The defendants in the gallery, they can't be on your jury. I think the state would probably object to them. And legally, because they're not a part of the rotation and they haven't been called up for jury duty, they can't be on your jury panel. So I don't even have jurors to go to a jury trial today. What I can tell you is this court is a trying court. And I think the defense attorneys and the prosecutors will tell you, we're usually in jury trial almost every week or every other week. Your case, while I know you feel it's old, it is not old for the criminal justice system. And your case, the first time that I had you in this court was October 29th. And then an attorney withdrew and your attorney on November 7th was actually in a jury trial. He can't be in 2 places at the same time.
But at that time, October 29th, he had asked for the court to grant him a reset for the next day, which would have been October 30th.
He's in jury trial. Let me ask you this. If you have somebody who's in jury trial, and I will tell you, he's on the 3G list. So he's not trying the state jail felonies, of course, unless somebody wants a trial on the state jail felonies. The cases that he is trying are major cases. They're like murder cases. They're like 3G sexual assault cases. So the question for you is, do you understand that defense attorneys need a break too? Like putting them to trial for 1 week and they finish on a Friday and then you say your next trial is on a Monday, they need mental health breaks as well. I've been a defense attorney, I've been a prosecutor. Even prosecutors need mental health breaks. So I think you want your attorney at his top performance, and part of being at his top performance is not being in back-to-back trials, which is what has happened with your attorney. You understand?
No,
So
I understand fully.
this is what is going to happen. On February 4th, that's going to be your plea deadline date. Either you worked out an agreement with the state or you have not. And then after that, you are getting your jury trial date. Can I give you a jury trial date in February? Yes, I can. But guess what? It's probably not going to go because we have a capital murder that the beginning of February. And then guess what? After that, we have a murder case. Then we have another murder case. Then we have another murder case. So I will put you in order as far as let the time that you've been in custody and whether or not you come up first before the other cases. Do you understand?
I understand. If you may.
All right.
If you may, now please say one additional.
Sure.
thing, please. And so I don't get this misconstrued or mistakenly speak. May I please grab what I'm finna say out of my photo, please?
I'm sorry, what?
May I please grab what I'm finna say out of my photo?
All right, what are your plans to say?
It's in regards to law.
All right, so
I don't want to mistake it.
all right, here's the thing. There is nothing that I can give to you. Sometimes I ask people, what is it specifically you want? So what I've determined from your questioning me is you want a jury trial today. It's not happening.
That's not what I'm saying.
All right, do you want a jury trial as soon as possible?
That's what I've been.
We will give you one as soon as possible. So thank you very much, okay?
But again, dear judge, again, a backlog case is not justification to.
Judge, may I be excused?
Not me
Yes,
thank you.
affording of my speedy trial.
All right, thank you.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? No. All right, counsel, you can please party your client.
Yes, I'd like to direct your attention to June 15th, 2023 and June 22nd, 2003. Did you fail to appear for a probationary instruction?
Yes.
And additionally, while on probation, you did accrue a new charge, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the probation violations. Enter a plea of guilty based upon your, enter a probation violation based upon your plea of guilty, and that would be technical violations 1, 2, 3, 4, and 5. And counsel?
Your Honor, I saw the recommendation for 60 days jail. I asked that my client get credit for the time that she's been in since December 1st. I'd ask that it run concurrent with the admonishment that she's received from the charge that she just took a plea on. And then furthermore, she did ask that during this time in custody, if possible, she would like the opportunity to be tethered to treatment. Thank you, Judge.
All right, Ms. Bolchak, did you request to be tethered to treatment while you've been on bond?
Yes, just to try to have time. I mean, I don't think I personally need treatment, but I know that that was something that I asked for when I first got arrested. So I'll do the days. I'll do whatever it takes, but I really just want to get home.
Okay, ma'am, let me ask you a couple questions. Number one, if you don't think you need treatment, why did you ask to go to treatment?
I was trying to have like the days made up. I don't know if I don't really know. Because
ma'am, you asked for treatment, so why did you ask for treatment?
Get out of jail.
I'm sorry?
To not have jail time.
Oh, that's what I thought. Okay, so, and you don't think you need treatment? Given what's been going on with you the last year, you don't think you need treatment?
Honestly, no. I really found myself in here. I've been spending time with myself. I don't know. I don't feel like I need a guy or anything. I don't know. I just want to get going on life.
Well, man, the way you've been going on life, not a great start. How old are you?
25.
25. And now you have 3 drug-related convictions. 3. Your under advisement status is revoked. You had an opportunity to not have your possession charge on your record, and you didn't do a darn thing with probation. Not at all. You just ghosted us.
I know, if I get probation this time, I told myself like, it would be at least 6 months. That's all I would really need to get like clean and, by summertime, I'd be, working. I really want to get a car. But aside from the job thing, just, I want to draw and make music and I don't know, I just want to do things for myself. And I like coffee again. I don't know, just things I've been drinking a lot of water. There's just a lot of things I wasn't doing before that like I've been doing since I've been in here. So I haven't.
Hey, ma'am, part of the concern, right, is when you get out, how are you going to continue to do stuff? Right? That's part of what treatment is, and you don't think you need treatment. So
I've been to treatment 7 times. I've been to treatment like 7 times. I don't know. I know how to work the program. I know to go to a meeting when I need to. I know there's just different times. I know.
So you go through the motion, you go through the motions. So you just go through the motions, you don't really receive what it is that you're getting.
I really think I've learned a different way. I've been incarcerated this time, ma'am. I don't know. It feels different. It feels really different. I'm willing to go any probation that you can.
Judge, we're ready to hear the sentencing. We are ready to proceed, Judge.
Yes, no, man, you're not getting probation, I can tell you that much. The court's going to, on 23405, the court's going to adopt the recommendation, revoke probation, close the case without improvement, $50 probation violation fee, 60 days jail. On 23739, the court's going to adopt the recommendation. Your under advisement status is revoked, your probation is revoked, $50 probation violation fee, 60 days jail. The court will note that will be served concurrent. And then the court's going to also order on 232479, the court's going to order 93 days jail. Credit for your 15 days. That's consecutive with 23739 and 23405. And the court will suspend your fines and costs on this matter. Any questions, counsel?
No, Your Honor.
Any questions, ma'am?
So, how many days?
Well, 60 on your probation violations plus 93, plus 15. So that's going to be, I can tell you exactly what that is, ma'am.
Is there any way I could do treatment?
138 days.
Is there any way I could do treatment?
And you told this court you don't need treatment.
Okay,
No, you told this court the only reason you said that is because you don't want to do the jail time.
No, that's
so
not.
You can do the jail time.
Ma'am, I'll do treatment.
And quite frankly, ma'am, with your lengthy warrant status and you're absconding from probation, I'm not sure that you would not abscond from your treatment provider.
Ma'am, I can't do 130 days.
Yeah, you said you didn't need treatment.
I do.
The problem was, when I went to sheriff,
I need help with housing when I get out of here. I'm gonna need.
I'm sorry?
I need help with housing when I leave here. I have my.
Okay, I need that talking in the background to please stop.
Somebody.
My court recorders indicated our record is a mess because of all the talking in the background. And what was that, Ms. Bolchak?
I really don't. I think I need treatment instead.
Ma'am, you were very clear. You've been to treatment 7 times and you don't need treatment anymore.
No, I do.
You know how to work the program.
No, I got a little ahead of myself. That's what I asked for when I first came in. Because I do have a drug.
Judge, potentially, Judge, I know that potentially she might be asking for some sort of mental health treatment, but I understand this docket does need to be moved along. So if necessary, we have to have the matter recalled later in the morning to potentially have it reevaluated. But I understand the docket does need to move along, Your Honor. Thank you, Judge.
Thank you. Ms. Bolchak, I'm not ordering treatment for you at this point because you stated that you don't need treatment and you only asked for it so that you didn't have to do jail time. Given that and the fact that you had absconded from probation with this court, the court is concerned that you're not going to abscond from treatment. So at this point, 138 days is what you're going to serve, ma'am. And we're all done. Thank you. Off the record. Have a good day.